midnight, I understand, but I retired at 10 o'clock. And we are now ready for today's program. We're going to start a bit unusual note today because we have a fantastic dance program that is going to be presented to you now. The artist is a very famous Bharatanatyam artist. Her name is Srimati Rukmini Vijay Kumar. She's going to come on stage in just a minute. She has performed all over the world and she has won accolades from everywhere. The New York Times described her as not just engaging but authoritative, with burning eyes that repeatedly catch the observer's breaths. Rukmini is the artistic director of a famous dance company called Radha Kalpa Dance Company. She's director of Lashwa, a creative space for artists in the heart of Bangalore. So she is a real, original Bangalorean, which is becoming a rare species nowadays. Because whenever we go out and talk to people in our mother tongue, you get stares at you because they don't understand it. And they prefer us to speak in Hindi, English, Gujarati, Marathi, or any other language, but Kannada. She's a graduate from the Boston Conservatory and recipient of many awards, grants. She is the founder, as I said, of Radha Kalpa Method, an educational system of Bharatanatyam that is based on idea neutrality. Her process of creation is both traditional and contemporary. She has performed as a soloist at global venues such as Jacob's Pillows Festival, Drive East NYC, and a number of other venues all over the world. Rukmini is also a writer, an author of several works, and an actor in theatre and films, an all-rounded personality in the field of performing art. I have great pleasure in welcoming her and requesting her to come on stage and give us her enthralling performance.
The Devi, or the goddess, is a form that we revere and a form that we pray to. She is the embodiment of all of creation and the creator as well. In this work, in this piece, it is an adoration of Devi, and the devotee beseeches the goddess to give her success, to give her the adoration of others. Rupam Dehi, Jayam Dehi, Yasho Dehi, Dvisho Dehi. Give me fame, but remove all my inner demons while doing that. This piece has verses from the Devi Mahatmyam and is composed by Dr. Rajkumar Bharati. An invocation to Devi.
Mm-hmm. नमो नमः ॐ हैं ह्रीं श्रीं श्रीमात्रे शिवप्रियायै नमो नमः ॐ ह्रीं श्रीं श्रीमात्रे शिवप्रियायै नमो नमः ॐ श्रीमात्रे शिवप्रियायै नमो नमः ॐ श्रीमात्रे शिवप्रियायै नमो नमः ॐ श्रीमात्रे शिवप्रियायै नमो शाम्भवी चन्द्रमौळिरबलाभरणा उमा पार्वते काली हैमवती शिवा त्रिनयनी कात्यायनी भैरवी सावित्री नवयौवना शुभकरी साम्राज्य लक्ष्मी प्रदा चित्रूपी परदेवता भगवती श्री राजराजेश्वरी
रूपं देहि जयं देहि यशो देहि द्विषो जहि
रूपं देहि जयं देहि यशो देहि द्विषो जहि रूपं देहि जयं देहि यशो देहि द्विषो जहि रूपं देहि जयं देहि यशो देहि द्विषो जहि अर्धनारीश्वरम्
kuda da kuda ta 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 kuda da kuda tam takda dim takda da kuda tam takda dim takda da kuda tam takda dim takda da kuda tam takda dim takda
शिवारूढा महाभीमां घोरं शान्तसन्मुखी चतुर्भुजां खड्गमण्डलवराभयकरां शिवां कुण्डमालाधरां देवीं जलचिह्मां दिगम्बरां एवं सञ्चिन्तये जाने स्मराता देवासिनी स्मराता देवासिनी ओम काली महाकाली भद्रकाली भैरवी नमो सजं ओम काली महाकाली भद्रकाली भैरवी नमो सजं ओम काली महाकाली भद्रकाली नमो सजं भद्रकाली नमो सजं भद्रकाली नमो सजं तम 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 नित्यानंदकरी पराभयकरी सौंदर्य रत्नाकरी नीर्दूता किल को माहेश्वरी प्रालेयाचन वंश पावन करी काशी काशीपुराधीश्वरी भिक्षा वलंबन करे माता अन्नपूर्णेश्वरी
Thank you for that exhilarating display of art, devotion. We'll take a few minutes. The program will continue. We're going to set up a small table on top. I request Honorable Chief Justice Virale Mr. Amarjit Chandiok to join me on stage. We will then continue the rest of the proceedings. My pleasant duty now to introduce our beloved, respected, honored Chief Justice from the state of Karnataka. As all of you know, Bangalore is the capital of the state of Karnataka, and the seat of the highest judiciary in this state is in Bangalore, and it is my duty to introduce our Chief Justice. Justice Prasanna Balchandra Varale comes from a family which is steeped in law. His father was a judicial officer. And after his birth in the small town of Nippani, which is now part of the state of Karnataka, I can claim that he is a Kannadiga and he belongs to the state itself. One more reason why I can firmly claim that he is from Karnataka is because his better half is from Karnataka. His Lordship had his schooling in several places in the state of Maharashtra, because naturally when his father was a judicial officer going to different places, he had to go along with him and have his education in all the places where his father was posted. He got an LLB degree from Baba Saheb Ambedkar University. He practiced law in the Bombay High Court, and he joined the chambers of a very renowned lawyer, Sri Satyanarayan Loya. He had a vast practice on civil and criminal side in the High Court, mainly at the bench at Aurangabad. He also had a stint in academics, being a lecturer in law in Dr. Ambedkar College, Aurangabad, his alma mater, from 1990 to 92. And thereafter, he worked as a government pleader and did many important matters for the state of Maharashtra. He was happily elevated to the High Court of Mumbai or Bombay on 18th of July 2008, and he served there with distinction till his elevation as the Chief Justice of the High Court of Karnataka on 15/10/22. Just a small secret about him, and I'll conclude the introduction and then request him to say a few words. He's a person with a very loving heart, especially when you see young lawyers appearing before him. He always gives them the longest rope possible, encourages them, and even when he finds that what they're saying is not right, he will never rebuke them. He will deal with them in a very compassionate, very considerate manner. Some senior lawyers sitting in court will say this is a waste of time, but his Lordship firmly believes that nurturing the young bar in the manner that he does it is absolutely essential for the bar to grow well. And for this reason, all lawyers in Karnataka are beholden to him, especially the young lawyers. With these words, I request Justice Varale to address the gathering.
My Lord, Honorable Dr. Justice D.Y. Chandrachud, Honorable Chief Justice, Supreme Court of India, My Lord, Honorable Sri Justice Sanjay Kishan Kaulji, Judge, Supreme Court of India, esteemed sister and brother judges present here, Shri Prashant Kumar, President, Bar Association of India, Shri S.S. Naganand, Senior Advocate and Conference Co-Chair, Bar Association of India, Shri Sham Diwan, Conference Co-Chair, Bar Association of India, Shri Amarjit Singh Chandiok, President-elect, Bar Association of India, Srimati Rukmini Vijay Kumar, Bharatanatyam dance artist, choreographer and actress, esteemed members of the legal fraternity, ladies and gentlemen, good morning. Ellarugu namaskara. Well, I can say that I'm very happy to share that I am son of the Karnataka and son-in-law of the Karnataka, and back to Karnataka again. It's a great privilege to deliver a welcome address to the 36th LawAsia Annual Conference in the august presence of my Lord, the Honorable the Chief Justice of India. I extend my heartfelt greetings to my Lord, the Honorable Chief Justice of India, and the legal luminaries from across the Asia-Pacific region who have gathered here under the theme, Everything, Everywhere, All at Once, Lawyering in the Digital Age. In the vast landscape of legal evolution, our annual gatherings provide a crucial platform for us to converge, share insights, and collectively navigate the complexities of our ever-changing legal environment. This year's theme is particularly apt as it encapsulates the transformative journey that the legal profession is undertaking in the digital age. The phrase, everything, everywhere, all at once, resonates profoundly with the challenges and opportunities that confront us today. The digital age has ushered in an era of unprecedented connectivity, transforming the way we practice law, dispensing justice, and engage with legal process. It demands that we adapt, innovate, and embrace the evolving facets of legal profession. As legal practitioners, scholars, and jurists, we find ourselves at the intersection of tradition and technology. The digital age has not only altered the landscape in which we operate, but has also redefined the very essence of lawyering. The emergence of new technologies, the advent of artificial intelligence, and the ubiquity of information have restructured the dynamics of our legal systems. The theme of the conference invites us to explore the vastness of this digital landscape where borders blur and information transits geographical boundaries. It challenges us to understand and harness the potential of technology while remaining true to the ethical principles that underpin the noble legal profession. The question we must ask ourselves is not merely how to adapt, but how to adopt sincerely, responsibly, ensuring the digital tools at our disposal serve the cause of justice and uphold the rule of law. In the digital age, the notion of time and space has undergone a profound shift. Legal practitioners now find themselves dealing with cases, clients, and information from every corner of the globe simultaneously. The interconnectedness brings both opportunities and complexities as we grapple with issues of jurisdiction, privacy, and ethical implication of practicing law across borders. The rapid pace of technological advancement demands that we equip ourselves with the knowledge and skills necessary to navigate this digital terrain effectively. It requires us to embrace continuous learning and engage in dialogue with experts from the various fields, including technology, cybersecurity, and data protection. By doing so, we can ensure that our legal systems remain robust, resilient, and responsive to the needs of ever-evolving society. While the digital age presents us with unprecedented challenges, it also opens the door to innovative solutions that can enhance access to justice, streamline legal process, and foster a more inclusive legal ecosystem. The use of technology in legal research, case management, and dispute resolution can significantly improve efficiency, making justice more accessible to all. However, as we delve into digital realm, we must remain vigilant guardians of justice, ensuring the benefits of technology are not overshadowed by its potential pitfalls. Issues of data security, privacy breaches, and ethical implication of emerging technologies such as artificial intelligence demand our careful consideration and thoughtful regulation. It is our collective responsibility to shape a digital future where the rule of law remains the cornerstone of our legal system. Technological evolution have had a beneficial impact on the Indian legal and court systems. A key initiative for this has been India's e-courts project. Information and communication technology has enabled more productive use of resources in court administration, thus improved overall efficiency and accessibility to the courts. Technological amenities made available under e-courts project have been widely adopted by stakeholders and lead to citizen-centric services. Introduction of technology and transformation taken place in our judicial setup necessitated to have looked at various processes in the system. The adoption of technology in our judicial system has led judicial process re-engineering, and same has become essential to tackle the issues of the system by reinventing itself. It is no doubt true that pandemic situation has led to growing need of digitization through the e-courts project, especially by creation of virtual courts, further giving a new space for potentiality of online dispute resolution, which further led to thinking of process re-engineering and automation of various processes of the courts. Karnataka High Court has been taking proactive initiative from time to time digitally transform judicial infrastructure, processes and practices. The High Court of Karnataka has taken several initiatives from time to time as a part of judicial e-infrastructure process and practices, including citizen and advocate-centric services. Digital courts deliver justice as a service to all. Beyond simply replicating offline process digitally, resultantly, access and inclusion are the core factors for achieving the founding vision. It also is designed to take an ecosystem approach that leverage the existing capacities in different stakeholders such as civil society leaders, universities, practitioners, and technologies to realize this future. In conclusion, as we embark on the deliberations and discussions of 36th LawAsia Annual Conference, let us embrace the challenges and opportunities that the digital age presents. Let us engage in meaningful dialogue, share our experiences, and collaborate to shape a future where the practice of law aligns seamlessly with demands of the digital era. I extend my gratitude to the Honorable Chief Justice of India and each one of you for your commitment to the cause of justice and your participation in the conference. May our collective wisdom and shared experiences pave the way for a legal landscape that transcends borders, connects cultures, and upholds the principles that define the very essence of our noble profession. Thank you. I wish you a fruitful and enriching conference ahead. Jai Hind, Jai Karnataka. Thank you.
The time that we awaited most anxiously is come now, but I will only be failing in my duty if I don't introduce a personality as great and grand as the Chief Justice of India, Honorable Justice Dhananjay Yashwant Chandrachud. Justice Chandrachud qualified with a degree in Bachelor of Arts from St. Stephen's College, Delhi, Bachelor of Law from the University of Delhi, and thereafter he went on to Harvard University and obtained a degree of Doctor of Philosophy in Law. He had a brief stint of practice abroad, and then he came to the Bombay High Court and practiced in a number of fields. He was awarded the INLACS scholarships and obtained a doctorate in the law on affirmative action in a comparative framework. He practiced in the Supreme Court of India and was designated as a senior advocate at the Bombay High Court in 1998, and later held the office of the Additional Solicitor General of India. He was elevated to the bench of the Bombay High Court on the 29th of March 2000. He took an active role in the Maharashtra Judicial Academy, which is an academy set up by several high courts for training judicial officers. He became Chief Justice of Allahabad High Court in the year 2013, and then he was elevated to the Honorable Supreme Court on 20th in 2016. He assumed the office of the Chief Justice of India on 9/11/22, and he has had a long association with several universities in India, United States, Australia, and South Africa, which is something very unique because in spite of his judicial office and in addition to all those onerous responsibility, he always had time for academic pursuit in several places in the world. My description and introduction of Justice Chandrachud will not be complete till I tell you a little bit about some of his judgments. He's been a liberal judge who always believes in upholding the rule of law and freedoms, individual freedom. His main concerns are these, and some of his judgments are touching the day-to-day lives of everybody in this country. The right to privacy. We have seen the judgment in Justice K.S. Puttaswamy's case. Free speech, how is it to be protected? In the decision in Chief Election Commissioner Vijay Bhaskar. Personal liberty with reference to press and media, Arnab Goswami versus State of Maharashtra. Gender justice, Young Lawyers Association versus State of Kerala. The rights of women, Joseph Shrine versus Union of India. The list is endless. You pick out any subject which is of absolute importance to ensure freedoms that are guaranteed by the Universal Declaration of Human Rights and by the Indian Constitution, you will see Justice Chandrachud's artistic hand in it. The repertoire of his vast learning and erudition, humaneness is borne out from his writings from the bench. These words, I have great pleasure to introduce the Chief Justice of India to this august audience and would humbly request him to kindly enlighten us with his illuminating address. Thank you.
Thank you very much, Mr. Naranan, for such a warm introduction. My very distinguished colleague, Justice Sanjay Kaul, the Chief Justice of the Karnataka High Court, Justice Prasanna Varale, Mr. Shyam Diwan, Mr. S.S. Naranan, Mr. Amarjit Singh Chandiok, distinguished judges, lawyers, and guests. Let me begin on a personal note. As we move into the discussions of the 36th session of LawAsia, we must pause for a moment and think of those who have mentored this organization. And I'd like to reflect particularly on Shyam's very distinguished father, Mr. Anil Diwan, who has mentored these global institutions. They have contributed to an international judicial dialogue, and perhaps more significantly, in pitchforking the Indian legal profession as one of the active participants in the global arena. I would also like to tell you a little bit about my own association, though virtually, with Rukmini Vijay. In the time of isolation during COVID, I followed Rukmini's performances very avidly, and her dance form, to my mind, represents a quest for fitness based on yoga and a blend of spirituality and form, which have inspired me personally to lead a more holistic and rooted existence. So thank you very much, Rukmini. I would like to start by congratulating LawAsia for building such a robust alliance of the legal fraternity in the Asia-Pacific region. In a world more interconnected than ever, these associations help us find meaningful partnerships, strategies, and avenues to share ideas and cultures. The theme of this conference, which is everything, everywhere, all at once, lawyering in the digital age, is fascinating. In the Oscar-winning movie, which is the namesake of this conference, we see a middle-aged Chinese-American immigrant who is confronted by multiple struggles like bankruptcy, accepting her daughter's queer relationship, running a business, taking care of her ailing father, and keeping her marriage intact. She gets in touch with her versions from parallel universes in which she made different choices and flourished. The protagonist jumps across the multiverse, acquiring skills from various realities, becoming an amalgam of seemingly irreconcilable selves, which reveal themselves to be inextricably linked. The underlying message there is that we are not singular beings, but we rather contain a multitude of versions. We are everything, everywhere, all at once. But at the same time, we are nowhere. We are not rooted in, nor do we belong in one place. We crisscross worlds and often even cultures. And that I do believe is the true message of the LawAsia movement. I've been asked to speak on the topic of identity, the individual and the state, new paths to liberty. First, I will talk about the historical context in which liberty was understood. Second, I will talk about the limitations of this understanding and the inclusion of identity and the state within the fold of liberty. Lastly, I will talk about the rigidification of identity and its reimagination as a path to liberty. The ability to make choices for oneself and change our course of life is called liberty. Identity intersects with a person's agency and life choices. As lawyers, we are constantly confronted with this intersection and the role of the state to limit or expand the life opportunities of people. While the relationship between the state and liberty has been understood widely, the task of establishing and explaining the relationship between identity and liberty is incomplete. Traditionally, liberty has been understood as the absence of state interference in a person's right to make choices. However, contemporary scholars have come to the conclusion that the role of the state in perpetuating social prejudices and hierarchies cannot be ignored. In effect, where the state does not intervene, it automatically allows communities with social and economic capital to exercise dominance over communities who have been historically marginalized. From the era of enlightenment to the struggles for independence from colonial regimes, liberty was primarily perceived as a freedom from external constraints, which is the liberty of the individual to act without interference from tyrannical rule. It was a vision rooted in the autonomy of the singular self, a narrative of personal freedom that resonated with the spirit of revolutions across the globe. John Stuart Mill, in his book on liberty published in 1859, discussed the historical struggle between authority and liberty, describing the tyranny of government, which in his view needs to be controlled by the liberty of the citizens. Mill divides this control of authority into two mechanisms. Firstly, necessary rights belonging to citizens, and second, that there must be constitutional checks for the community to consent to important acts of the governing power. The idea of liberty as personifying unregulated freedom can be summarized in the phrase that your right to swing your fist ends where my nose begins. This form of liberty champions individual rights, but is agnostic to identity because it allows the free exercise of options by an individual without state interference. Yet, as we navigate the currents of time, it becomes imperative to acknowledge the limitations of this historical understanding of liberty. To understand traditional liberty, imagine that each of you is driving a car and you come to a fork in the road. You turn left, but no one was forcing you to go one way or the other. So you seem as a driver to be completely free. Therefore, the driver would have complete liberty in the traditional sense. But this picture of your situation might change quite dramatically if we consider that the reason you went left is that you are addicted to cigarettes and you are desperate to get to the local pawn shop or the local 911 to buy a packet of cigarettes. You long to be free of this irrational desire that is not only threatening your longevity, but is also stopping you right now from doing what you think you ought to be doing. Here, liberty would mean that you must have agency over your actions to decide what is best for you. The individual, though a crucial player, is not an island unto themselves. Identity, woven intricately into the fabric of our existence, cannot be divorced from the discourse on liberty. It fails to take into account that individuals do not have equal agency to exercise their freedoms with or without state interference. Therefore, people who face marginalization because of their caste, race, religion, gender, or sexual orientation will always face oppression in a traditional liberal paradigm. This traditional liberal paradigm empowers the socially dominant in two ways. First, it removes state fetters from them to act as they please. Second, it emboldens dominant social groups to exercise their existing dominance to oppress marginalized populations. The state, often viewed as a potential threat to individual freedom, has now been re-examined within the broader scope of liberty. Social movements throughout history have pointed out the inherent hypocrisy in the claim that liberty is agnostic to identity by pointing out that systemic social discrimination is so embedded in the system that is often assumed to reflect the natural order of things, that the natural order in which negative liberty is presumed to operate is actually an economically affluent, upper caste, cisgender, heterosexual, male perspective is actually an economically dominant perspective today. Its identity and its recognition by the state plays a crucial part in what resources people get and their ability to express their grievance and demand better rights. The state therefore confers personhood and juristic personality as the first step in recognizing the claims of entities and individuals. In our digital age, we are now faced with several fascinating aspects of artificial intelligence. There's a complex interplay between artificial intelligence, AI, and personhood, where we find ourselves navigating uncharted territories that demand both philosophical reflection and practical considerations. In contemplating the intersection of AI and personhood, we are confronted with fundamental questions about the ethical treatment of these technologies. This scenario evokes reflections on Sophia, a humanoid robot, as an example that had captured the public's attention. Sophia can engage in conversations, express emotions through facial expressions, and was even granted citizenship in Saudi Arabia. While a humanoid robot was granted citizenship, we must reflect whether all humans who live, breathe, and walk were entitled to personhood and citizenship based on their identity. History is replete with examples of state prejudice based on identity. In this context, it made sense for social movements to demand that their identity be treated with respectability and create better conditions for the exercise of liberty. For example, laws framed around the gender binary have historically led to the concentration of wealth in the hands of men. These laws commit a dual fallacy. First, they assume that there are two and only two genders that must be distinguished. Second, they actively disadvantage women and advantage men. These laws could look like seemingly neutral criteria of lifting, for example, 3 times the body weight of a person for the selection of a firefighter. Not only is this criteria unrelated to the job of a firefighter, but it invisibilizes the anatomical differences between different sexes, thereby restricting the employment and economic opportunities of firefighters only to men. The Supreme Court of India, in Anuj Garg versus Hotel Association of India, was faced with a challenge to Section 30 of the Punjab Excise Act, which prohibited the employment of any woman in any part of an establishment in which liquor or any other intoxicating drug were consumed. Our court, in striking down this patently discriminatory provision, held that a sex-based classification cannot be justified on the basis of a blanket assertion of natural differences between men and women under the anti-stereotyping principle. In the Secretary, Ministry of Defense versus Babita Punia, which was delivered just on the annual of the COVID-19 pandemic in March 2020, the Supreme Court rejected the notion that a woman is the weaker or inferior sex. And in doing so, it held that arguments founded on the physical strengths and weaknesses of men and women and on assumptions about women in the social context of marriage and family do not constitute a constitutionally valid basis for denying equal opportunity for women officers in the Indian Armed Forces. And therefore, today we have women at the forefront of our borders. They are in the high seas, manning our naval vessels, and they are fighter pilots in the Indian Air Force. These cases show how identity has been used as an assertion for guarantees against discrimination by the state. Because there is discrimination based on people's identity, we see resistance also centered in the vocabulary of identity. Another notable dimension is the intersection of climate, tribal rights, and challenges stemming from rigid identity impositions. As a scholar, Talal Asad points out, the responsibility for safeguarding human rights is often placed in the hands of individual sovereign states, whose jurisdiction is bounded by national economies. This framework, unfortunately, fails to address harms perpetrated on one's country's economy by another, even if it inflicts irreparable damage and suffering on a large scale, as it does not constitute a violation of human rights of those who are affected. In this context, we must acknowledge the inherent complexities within the culture of law, which is saturated with power imbalances. The human rights culture, far from being a transcendent language of justice, often articulates inequalities which are embedded in social life. This then raises the question, is the discourse on human rights the sole language through which we can articulate justice? To extricate human rights discourses from entanglements in webs of subjugation and disentitlement, we must broaden our perspective. The notion of popular sovereignty, for example, inherently demands the inclusion of pluralism and diversity at its core. An exploration of the struggles for survival and dignity by constitutional collectivities, such as our scheduled tribes in India, underscores the imperative of imagining life worlds of freedom and dignity. For tribal or the Adivasi communities, the right to liberty finds expression in territoriality, homelands that confer a particular identity and enable distinct livelihood practices. Their struggles, particularly around issues of forest rights, governance, autonomy, and self-determination, exemplify the embodiment of autonomy and sovereignty encapsulated in the tribal or the Adivasi slogan, Mava Nate, Mava Rai, our land, our rule. These and many such assertions of identity in the face of discrimination have provoked two trends globally, one of affirmative action and the other of understanding multiple identities through an intersectional analysis. In India, affirmative action has been prescribed, even mandated by the Constitution, in the context of the scheduled castes, the scheduled tribes, and the backward classes. Caste, far from being a vestige of the past, continues to exert significant influence on contemporary socioeconomic and political landscapes. Its resilience is evident in the social stratification, economic disparities, and access to opportunities experienced by different caste groups. I would like to note that caste dynamics in the region are not exclusively shaped by religious affiliations. The intricate caste system is not merely a response to historical inequality, but functions as a potent tool for disrupting entrenched societal structures. Many reports in India, such as the Sachar Committee report and the Justice Ranganath Committee report, have brought attention to the widespread abuses which are faced by marginalized communities, including social segregation, untouchability, limited access to education, and underrepresentation. These findings underscore the pressing need for affirmative action to address deeply rooted discrimination. Within this complex tapestry, affirmative action emerges as a transformative force, challenging established caste dynamics. It goes beyond the misconception of caste as a solely cultural phenomenon and serves as a catalyst for change. I remember that one of my predecessors, Chief Justice Sharad Bobde, recognized the necessity to consider the social exclusion of Christians and Muslims from the scheduled caste, reinforcing the urgency of addressing these issues. The argument unfolds cohesively, illustrating how affirmative action acts as a beacon of hope, working to dismantle age-old caste-based inequalities and paving the way for a more equitable future. Implicit in our conversation around identity is our assumption that people hold one identity at a time. How untrue. Identity and its conversations have thus embraced the tendency of becoming the domain of the oppressed, because the identity of socioeconomically advanced segments have already been translated into material capital. Not only does this attach a trope against those pointing out tangible ways in which society is prejudicial to communities, but it also does injustice to those upon whom multiple vectors of identity operate to create unique patterns of marginalization globally. Scholars like the very distinguished Kimberly Crenshaw have analyzed the theory of intersectionality. Other feminist critiques like bell hooks prefer not to use the term intersectionality. According to bell hooks, the society as it exists itself is rooted in the identities of the privileged. She prefers to use the more elaborate term of white supremacist, imperialist, capitalist, patriarchy to highlight the knitting together of identities which have led to maldistribution of liberty in our contemporary world. This is not just an academic discourse, it's a real-world issue affecting lives across the globe. Let me tell you, by delving into the intricate landscape of intersectionality for a brief moment. A very distinguished Indian scholar, Nivedita Menon, and another scholar, Rita Dhamon, have astutely critiqued the concept of intersectionality, while a powerful analytical tool faces challenges in its application. I have applied intersectionality myself in several of my judgments. The theorization of multiple and interlocking vectors of identity have led us to question its efficacy in diverse contexts. As Menon contends, it undermines traditional forms of patriarchy, but risks being depoliticized, leading to an ornamental intersectionality. We must then navigate the tensions between disciplined feminism, the commodification of analytical categories, and the risk of superficial challenges to existing power structures. So then, what is our path forward with intersectionality? Despite these critiques, we must view it as a powerful mechanism for unraveling the simultaneity of subjugations and building coalitions across different marginalities. It is all about recognizing the interlocking systems of power that shape our lives. Identity has been portrayed as an essential inherent component of the self, while no doubt the effect of unfair distribution of life opportunities based on identity are very real. But the distinction based on identity was created to serve no useful purpose. And I said an assertion based on identity is a natural and valid response to the identity-obsessed world in which we live. However, it has reified the false distinction between people based on their identity. Knowledge in this case is always partial and contextual. What we know is only ever a part of the picture, and it is based on who, where, and when we are. Knowledge cannot be neutral or objective. No knowledge is ideologically neutral. Knowledge is contingent on systems of power, and it shapes the power relations between people. In the course of understanding identity, the individual and the state, we see our own transforming understanding of liberty. Whereas the traditional understanding of liberty falsely claimed it to be agnostic to identity, the new age understanding is not without its demerits. In our well-founded assertions of identity, we must not forget that removal of the underlying systemic discrimination would require us to abandon the notion that people must be categorized into boxes. Boxing of people into rigid identities is one way in which society may deprive communities and individuals from exercising their freedoms. As the queer feminist scholar Gail Rubin's work highlights, there are dangers inherent in identity-based assertions. We can fight to get our group into the charmed circle, but other groups further down the line will continue to be marginalized, pathologized, and criminalized, often those who are already the most oppressed. The boxing of people into rigid identities is also a byproduct of over-identification. For example, the division of people with disability to afford state benefits, instead of making accessible infrastructure and disability-friendly education and employment sectors, people with disabilities are forced to get a certificate for entitlements under the Right of Persons with Disabilities Act of 2016. This has led to the problem of creating a benchmark for disability to avail of state benefits. This has led to, first, many disabled people falling through the cracks because they cannot be boxed into a benchmark scale. Second, it has distracted from the larger solution of fixing our overall physical infrastructure. And third, persons with disabilities are still relegated to an inferior status in need of state rescue because it is taken for granted that they are an exception to normal and will require special accommodation. We need not look any further to understand an alternative world where we are able to move beyond our need for over-identification than to see the example of persons who wear eyeglasses. People like me who wear glasses are not considered persons with disabilities because eyeglasses have been made widely available. The stigma against people with specs is non-existent, and no practical difference exists in the distribution of life chances between people with or without eyeglasses. Therefore, as I wrap up, may I say, while the journey of liberty has aimed to maximize human freedoms, it is our life's work to imagine liberty as the removal of systemic barriers and make oppression-based identities obsolete. This is not to say that persons with certain identities will be invisibilized. However, the stigma and the difference attached to them would become part of a benign distinction, one of several that humanity cherishes even today. I thank you very much for inviting me to share my thoughts with you, and I wish the deliberations over the period of this conference the very best from the bottom of. Thank you very much. Namaste.
I request Mr. Chandrachud to please address.
The Honorable Chief Justice of India, the Honorable Chief Justice of Karnataka, my Lord Justice Kaul, eminent honorable judges across the country, across the world, Mr. Prashant Kumar, Mr. Shyam Diwan, Mr. Nagaranji. Welcome to this first session on the second day, which we started with Bharatanatyam from Rukmani, and the way she demonstrated the culture in terms of what religion actually means, what could be the way how you can reach the God, the access, what we call, she said, access to God. We always talk of access to justice. So that's the similarity between the two. Our Honorable Chief Justice of India has taken us far and wide between identity and liberty. It's difficult to comprehend each word that His Lordship has said, but to give you the crux of the whole thing is that one has to look at the identity with liberty and the state's role in doing so. His Lordship gave the instances right from starting the world, how we understood identity and liberty earlier, brought it down what we should do it in digital age, and actually told us everything, everywhere, all at once by his address today. I think that would be the best way I could sum up His Lordship's words. And to say that marginalized people will be able to do something under the Disability Act, when His Lordship talked about his own specs, I think a lot has come through it, but the digital age is making its own challenges. We have to bring transformation, there's no doubt in terms of my Lord. And what we will do tomorrow is a collective effort to ensure that actual liberty is granted to people, which is actual format that we see. This discrimination by virtue of the fact that we are men and women or some transgender must be given way to something more important, that we are all humans. It reminds me of a Chief Justice when put that how do you select your honorable judges? His only answer was, I look, he is a gentleman. If he knows some law, then it is a bonus. So that's the position that we look at. My Lord, the Honorable Chief Justice of Karnataka gave us what the digital age means, what should it mean to us, and how do we adopt to the cause of justice. And I'm sure with the guidelines that we have already done, what all our courts have done, in fact, the Honorable Chief Justice addressing us at Delhi High Court said, I will need to come to your court thanks to my Lord Justice Kaul, who has been possible for all that infrastructure. They have to learn how we have developed infrastructure. In fact, many of my colleagues here or delegates here, participants yesterday put to me, how is it that the Lordship has 120 matters a day and you're able to dispose it off at one go? I said, that's the art that we need to learn and probably shift it to all over the world to see how justice can reach each individual so that we can transform them, their liberties into actual liberty to be exercised, be it individually. Thank you very much for each one of you to be here. Thank you.
As we conclude this session, we'd like to particularly thank the Chief Justice of India and the Honorable Chief Justice of Karnataka for having been with us, spending time and giving us a lot of food for thought, which we are going to discuss. Thank you very much, sir. Thank you to all of you. We now break. I request all the guests here to kindly leave the auditorium and enjoy the air outside, because they're going to move this hall into 2 chambers. We're going to have our continuing discussions here. In A and B is going to be here. C is in the other side of the hotel. Therefore, kindly allow the hotel staff to rearrange the chairs here. Thank you.